that there are about 3 million garnishee orders in place in South Africa. Many of them are said to be fraudulent because they were not issued by magistrates as required by law. Normally, a debtor is summoned to court and given the opportunity to defend any claim by a credit provider. They are supposed to give the magistrate good reasons why the garnishee order should not be granted. But in most cases, consumers are never afforded this opportunity and are not informed on time about their garnishee orders.
The Treasury wanted to do away with garnishee orders, but I think they have negotiated with the credit providers to introduce more palatable ways of managing the process going forward. But this still doesn't answer the question is what happens to those garnishee orders in place at this point in time.
Experts say the high number of garnishee orders is caused mainly by reckless lending. Many credit grantors still do not do an affordability assessment to determine if consumers can afford the repayment.
They tell the credit provider what the credit provider wants to know in order to get the loan approved. That's the first problem. The second problem is that in some cases the assessment doesn't follow the guidelines set down in the NCA, and that means that some of those agreements could be reckless.
A task team comprising the Council for Debt Collectors, the Credit Bureau Association, the Banking Association and the National Treasury wants to reform the system.
We've agreed that we will put together a set of criteria that need to be met. One, to make sure that abuse is minimized, if not gotten rid of totally. Two, to ensure that we do show that it's used as a last resort mechanism and for no other purposes. Three, that we also deal with the abuse in the Magistrates Court system and the Magistrates Court Act.
The National Treasury wants garnishee orders to be issued only as a last resort once all other avenues have been exhausted. Some consumers have about 10 garnishee orders, and this means they are left with little take-home pay. Consumers facing financial distress are advised to opt for debt counseling. If you are undergoing debt counseling, you cannot be issued with garnishee orders.
We've all agreed, the entire credit industry together with government, that garnishee orders can be an effective tool for collecting debt, okay, provided it's used properly and provided it's used as a last resort mechanism, right, when all other mechanisms have been tried and a borrower does not repay loan that he or she has taken.
Garnishee orders compel employers to make deductions from their workers' salary to pay their debt. If the employer fails to do this, then their movable business assets can be sold to settle an employee's debt. The Public Finance Management Act only protects 40% of government employees' gross salaries from any deductions resulting from court orders, but ordinary consumers are not protected by this.
Perhaps it's a sign that the state has been careful to protect their own employees in regard to garnishee orders, and that employees in the private sector, that protection does not exist.
Initially, the National Treasury wanted to scrap garnishee orders completely, but after much deliberation, it has now been decided that garnishee orders should rather be regulated. Naledi Mulifi, SABC News, Johannesburg.